Good evening, ladies and gentlemen. My name is John Leonard. I'm chairman of the Board of Appeals. This is a hearing on March 24th, 2022, in order to discuss further the decision on the application for the Villages at East Milton Square. Also with us tonight is Board Member Jeffrey Mullen and Board Member Nick Gray. Judy Barrett is with us as well. So, hi, Judy. How are you?
Fine, thank you.
Good.
And you?
It's been a hassle. I've been using the number that I've always used to join meetings, and for 5 times in a row, it wouldn't take.
Oh dear, I'm sorry.
No, that's all right. So I apologize. I must have had the wrong number, but it's the one I use on my printed form here. So, in any event. Good to see you again, and thank you for the wonderful decision.
Thank you.
It would take me 3 weeks to a month to do that type of decision.
I'm sure that's not the case.
Maybe exaggerating a little bit, but
Tim is on with us too, John, in case you can't see that.
I can't see Tim, but his name is printed on the screen. So
okay, super.
So that's fine. So we're here to further discuss the decision in this East Milton Square application. And let me see, Jeffrey, do you want to start the discussion, or do you want me to start it?
It would be great if you started, John, if you can.
Well, I can, and unfortunately, I may start it on the long side because I think when I read Judy's draft decision, which was very thorough and comprehensive, and I read peer reviewers' reports and all of this, and I read some of the legal research that you did, Jeffrey, for which I sincerely appreciate you. You're doing this. I think we have an issue of process here to discuss, in the sense that it appears to me, based upon what we've said in the past and what I've read, is that the concern of the board here is the size and density of this particular application. And that we've had this application reviewed by 2 experts in the field, Sean Reardon and Cliff Bomer. And what they've done is taken the applicant's position and testimony, including the testimony of expert witnesses, and have rendered multiple reports and comments on that application. And as a result of that, the application was modified substantially in scope of the number of units and dimensions of the project and all of that. And from my recollection, I'm not going to read engineering reports to you, but Cliff Bomer seems to believe that the project, he says, is a suitable 40B project, and that the site is appropriate. I look at Cliff, strike at Sean Reardon's various reports, and he concludes that there aren't any deal breakers in the issues that remain between the parties, but the issue really is one of the board's decision as to what type of a project the board wants to have under the circumstances. I think both Cliff and Mr. Reardon believe that the project is very, very dense, but I think their conclusion is it can be built with the modifications to the project that the applicant has made. And so the the issue tends to be the applicant is saying here that I believe there are 91 units, maybe 92 units. And if the application is reduced below that, they say that they're at a 5% profit margin at the present time, but that if they go below 91 or 92 units, the project is going to be financially not feasible. So at that point in the proceeding, the applicant indicated that the Corcoran Company had produced a feasibility financial analysis for the property, and that Jen Corcoran had that in her possession. And to the best of my knowledge and belief, that was never introduced into evidence before the Board of Appeals. So to justify the statement whether the project would be rendered not economically feasible if the number of units were reduced. And I do recall some testimony from Mr. Freeman, or at least statements by Mr. Freeman, that they either had retained or were going to retain Bob Engler to do such a report, perhaps a little more formal in scope than I'll call it the Corcoran Company's analysis. But I don't know whether they hired Mr. Engler, but we certainly haven't received anything from Bob Engler regarding the financial feasibility of the project. So that we're in the position that there's no evidence to contradict whether they are at the 5% level, but there's no evidence to support it other than Mr. Freeman's statement, and I'm not sure that's technically evidence. So we thought, I think at the last hearing, but it was discussed very briefly, that we could take a look at whether the issue of financial feasibility could be further analyzed and discussed at this meeting, and whether it was appropriate for perhaps to condition any decision that the board may render on the density issue, the number of units, on a finding by the Housing Appeals Committee that decreasing the number of units would in fact make the project not feasible, since the applicant didn't introduce evidence to that before the Board of Appeals, and they had plenty of opportunity to do so. My recollection is also that we indicated to the applicant that, and this was a couple of hearings before the end, that if financial feasibility was going to be an issue, then the board would retain an expert to opine on that issue. And I think Judy Barrett did speak with an expert who indicated that it may take 4 to 6 weeks at the earliest to have that type of analysis done. And the applicant was insisting that the public hearings end because we've gone beyond the 180-day period. So in a sense, the board did not have any opportunity to conduct a study if financial feasibility was going to be an issue in this case. I think it would have been helpful to learn that early on and not when the hearings were winding down, because we would have had plenty of opportunity to address that issue in a cogent way. So when we were discussing this, Mr. Mullen was very gracious and did some legal research on the issue of financial feasibility and when it's admissible and the like, and he found some data and authority in the manual regarding 40Bs, which indicates, generally speaking, that the board may be prohibited from reviewing a pro forma to see whether a project would be economic if the number of units would be reduced, unless the so-called reduction is justified by a valid health, safety, environmental, design, open space, or planning, or other local concern. And I guess we do have concerns about the open space issues here and the density of the property. But the hearings have closed. We have no evidence on this one way or the other. So to me, I think we're kind of in a quandrum there. We have the evidence that's before us, but we don't have the evidence that would prove that the project is going to be rendered unfeasible with a reduction in the number of units. And the issue is, if we do go to seek a reduction in the number of units because we think the project is too dense, then we have to justify that by a valid health, safety, environmental, design, or open space or planning concern, which is very broad. And then the question is, if we go in that direction, how does one derive a reduced number of units both based upon those factors? To me, that's mysterious. It's like flipping coins. And I don't know so we're in a position here where I think everyone believes, number one, our experts say this project can be built with good engineering practices at the level of 91 units. The board thinks that, well, it's built out to the lot lines, essentially. We know that the applicant has tried to accommodate Mr. Bomer and Mr. Reardon's concerns on the technical aspects of the project. But how does one justify a particular number of units on health, safety, and environmental or design grounds? And on what evidence is that based? That's my concern. So I threw out the possibility of finding that the 91 units would be an appropriate number of units, so long as the feasibility of the project is at the 5%, the profit margin is at 5%. And that if it were more, then the number of units should be decreased. But if it were less, then it would render the project not financially feasible. So that's the quandary that I'm in here in terms of where we are. And I don't know how, other than hiring a mystic or flipping coins, you can come to a determination on number of units that would be financially feasible on the present record, or based upon the evidence that's before us. And that's where I'm stymied. So Jeffrey, you've done the research on this. What ideas or what viewpoints do you have on this issue of the 40B regulations prohibiting a review of the pro forma on the basis of number of units by the Board of Appeals?
I don't pretend to be an expert on it, John. I mean, I did look at it, but my understanding was the whole issue of the viability of the project finances is something really reserved to the Commonwealth. And, the subsidizing agency, I should say, Mass Housing, not the Commonwealth per se. So I guess my view is that the project will always meet the limit on profitability threshold because it's built into the statute. And that it's a presumed fact that this project, the profitability on this project cannot exceed what's permitted by the program, and that's something that would be established by the subsidizing agency. Both Judy can correct me because I think she's the expert, both at the completion of the project and on an annual basis thereafter.
That's correct.
I do think cost is a very difficult issue to nail down. And I think one of the issues that we faced during the public hearing was that even if we were permitted the time to have it, to have the time to do the pro forma, it would be still a very difficult issue to establish. So I guess I've come to the point where the issues around density need to be addressed with respect to the particular features of the project and the mitigation measures that sound in local concerns based upon the testimony that we've heard throughout the hearing. That's my view. That's why I think we are, and one attempt to address your legitimate concern, but Judy might be able to amplify that if you'd like, or obviously Nick can speak to it. But those are my thoughts.
Nick, do you want to? Or do you want to hear from Judy? Let's see.
I'll hear from Judy. Yeah.
Please. Judy, help us out of our quandary here.
So, you are in a kind of a tough spot to know whether a reduction in units would make the project uneconomic because you don't have the information. The reality is that once the project's approved, assuming it's approved and it's eventually built, the subsidizing agency will look at the profitability of the project, both at completion and then on an ongoing basis, because it's a rental project. So you're looking at the payout every year, but up front, you're also looking at total development costs and whether the developer, whether the profit out of the development phase was within limits. And so, if for some reason someone ever goes over the profitability limit that's allowed on an annual basis, it essentially ends up in a reserve to support the project. So it doesn't get paid out as a dividend. Mm. That's a separate issue from what the board's got to find. The situation you're in right now is if you reduce the number of units, would they still be able to make enough money to make it a profitable project and have it financed? And you don't know that. So between sort of making it barely profitable and making it profitable enough to get financed and go forward, you're kind of in this space as a ZBA where if you had that information, you would know, well, they still could make the project go forward. We're not going to be ruining it by taking 10 units off. You don't know that now. So the position you're in is if you really felt strongly about it, that you really thought the project was too dense or too high or whatever, you may choose to make a reduction in the scale of the project, not knowing whether it's going to be made economic. And then if it goes to the Housing Appeals Committee, at that point, you can hire a financial expert to testify on the board's behalf. I'm not advocating for that. I'm just saying that's your choice. And there are boards that don't bother going through this at this phase, in the hearing phase, either because they can't get the review done or the applicant doesn't cooperate. And so it all gets hashed out at the Housing Appeals Committee anyway, because it's a de novo hearing. So I think you have to go with what you think is the right thing to do based on what's in the record and based on, as Nick was saying a week ago, what you know about the area. And if it makes the project uneconomic, I think we have to sort of tilt the decision to say, if there are conditions in this decision that make the project uneconomic, we think that the local concerns outweigh the regional need in this case, because that's the position you end up in. Does that help at all?
I think it's very helpful because I think it's an accurate reflection and interpretation of the law as we know it. The difficulty is it's being applied in a vacuum.
Yeah, I know.
And it makes the board look as if it's guessing or not acting on the basis of the evidence presented. Is it rational to suggest that if the applicant has refused to offer evidence that a further reduction in the number of units below, let's say 92, would render the project economic, to enter a decision that he can have his the applicant can get its 92 new units if that's true. But since they didn't prove that before the Board of Appeals, just flip this application to Hack and let him prove it at the Housing Appeals Committee.
That's
rather
what,
than,
I'm sorry, John.
no, I was just saying, rather than our engaging in mysticism or picking 75 units, for example, and then have everybody say, oh, this is Milton. This is what you get in Milton. They don't like 40Bs in Milton. And what's the basis for the finding of 75 units? Is it traffic count? Is it the size of the height of the building? And it makes us look like fools. So, and as you say, the whole application, no matter how we decide it, has no evidentiary significance before Hack. It's a de novo proceeding.
It is, right.
So if the applicant here is unwilling to present us with the evidence to justify an award, can we just send it to Hack without a decision and just indicate the state of the evidence was?
It only goes to the HAC if the applicant appeals your decision.
John, can I share a quick thought here?
Yes, please.
So the way that I look at this is really the board should be, I guess, agnostic on unit count, except to the sense that the unit count is a function of all of the other physical components of the project. So I think if you're concerned about conditions that may reduce the unit count, I think you really need to think about it as, here's a problem, for instance, just as one example of, here's an issue that we found, backed up by our peer review experts with the structure and the design of the parking garage. And we feel that the parking garage needs to be shaped in this way. And that's your justification. It's based in a local concern around health and safety and welfare, and the unit count kind of goes where it goes. A way to thread the needle would be, and Judy can tell me if this is way off base, but an approval that allows for up to 92 units. And if it's below that, then it's below that. And if it hits that, it hits that. But I think you really do have to look at this as conditions that are addressing the physical components of the project that are affecting the health, safety, welfare, local concern.
Well, that's true. And we can discuss those issues, but they're relatively insignificant issues as to whether a project of this size and density should be approved by the board. At least I think. We can talk about parking spaces and we can talk about delivery of packages and all of this, but we're really dealing with I think, relatively superficial issues considering the nature of the project that's being proposed. And I agree. If we're agnostic as to unit counts, then I guess what you're saying is we deal with the nitty gritty here, wait a decision, and let Hack decide that issue of financial feasibility, or let Bob Galvin on behalf of the East Milton Neighborhood Association raise that challenge before the Housing Appeals Committee, and presumably they'll have plenty of time to do that.
So I think one way you kind of stay agnostic about the number of units, but deal with the physical components of the site is, do you think the building's too tall? This is a classic example. This actually happened in another community where it wasn't really about the density. It was about the height of the structure and the impact of that height on adjacent properties. So, if you were persuaded by the neighborhood's concern, I'm not arguing this in favor of this. I'm just saying this is an example. If you were persuaded by the neighborhood's concern about shadow impacts, about lighting from upper story units and the effect of that on low-rise surrounding single-family dwellings, you might say, the building is too tall. The neighborhood is right, the building is too tall. So we're going to take it down a floor. Well, by definition, you end up reducing the number of units in the project, but it's not because you're trying to get a density. It's because you're trying to reduce the lighting and shadow impact on surrounding properties, if such impacts, or exist to the point that it's actually detriment to the neighborhood. So that's an example of where a design consideration, which is clearly within the statute, leads you to a reduction in number of units.
Yeah, that makes consummate sense, but it has nothing to do with this case because Sean Reardon doesn't think the building is too high, and the Cliff
doesn't.
He thinks they've staged back the fourth and fifth and sixth floors, and they've complied with his request. So we're contradicting the evidence of our own peer reviewers in doing that. I guess we can do it. We look foolish doing it.
But you still then have to decide as a board, are you comfortable with that?
Now, could I try to weigh in here?
Sure.
I'm not really sure if I'm going to make a decent argument, but I just want to share with you the thoughts that I've been having about this. I want to just take a step back for a second and remind us that we're talking about a project that is one of the largest buildings in East Milton. It's going to be here for decades after we're long and gone. And the impact of this building on the neighborhood is going to be with the town and the neighborhood in perpetuity. Well, at least until it's torn down and whenever that is in the distant future. So I think that there is no greater local concern, I think, than traffic and parking and delivery of servicing of this site. I think the universal, with one exception, universal testimony that we got from the neighborhood association and from members of the neighborhood expressed concerns about the effect that this building will have on negotiating one's way around in a car through East Milton, the parking at the building, and the height of the building casting shadows and looming over the neighborhood. So that is testimony that I think we're allowed to take into account and inform our interpretation of what our own experts and the applicant's experts have told us. Do you think is that
yes,
fair to say? It's testimony in the same way that the experts are testimony.
Yes, absolutely. It's not less valid because it came from the neighborhood.
So given the fact that the nature of this building's impact on the neighborhood, I think that there's a certain, at some level, we have to apply common sense as well. We all have our judgment about what effect that type of building could have on that neighborhood. And I think that's important to keep in mind in determining what conditions we might apply to the project and in how we're guided in interpreting the evidence that we've been presented by the experts and by the neighborhood. So I don't know what that leads us to. My overall sense is that a reduction in the size of the building would certainly help with the shadow issues and would also help by nature of common sense with the traffic impacts and the parking impacts on that building. A reduction in the size of the footprint might allow for some more space to be able to do deliveries to that building that don't interfere with the flow of the neighborhood. So those are just my thoughts. I'm happy to hear what you guys think. And I'll leave it at that for the moment.
Okay, let me comment on that, Nick, because I appreciate your candor and your zeal and your analysis. Your analysis is fine, but you're acting as a planning board. And we're not the planning board. We're the Board of Appeals. And our job, as I see it, as members of the Board of Appeals, we're sworn to listen to the applicant and adjudicate the application that's presented. And we did that. And we hired two great experts to analyze the application they had many criticisms of the application, and the applicant made many changes in the application, so that now both of our experts, to the best of my knowledge, and I've read their reports, indicate that this project can be built technically as they have approved of it. So when we, as the Board of Appeals, then start to say, well, we think it should be a lesser number of units, well, that's like a judge at a trial in the Superior Court listening to advocates and saying, well, but that's not how I feel about it. And you say, well, wait a second, you're supposed to be the judge. You're supposed to judge the evidence, not to tell us what your personal viewpoint is on anything. And see, that's the problem that I have here. We've got great experts, and they essentially say the project can be built. And we think, well, maybe it's too heavy, maybe it's too high, and all of that. But when you look at the evidence as a whole, and one of the pieces of evidence that I find compelling in this particular decision is the East Milton review of zoning, and that was issued by Judy and her firm in 2021, I think it is.
It was last year.
Yeah, and one of the things that particular analysis concluded, it showed in in the third version 4 or 5 buildings that are at or about this size in East Milton Square, and said that is the way of the future. It says that the cost of land and the cost of construction in the Boston metropolitan area are quite high. The result is that generally taller buildings are required for projects to be economically viable. Though the projects vary, its buildings are quite often in the 4 to 6 story range. And it says this is especially true for projects with affordable housing. And what you do, and then it goes on to talk about the reality of East Milton Square. It says planning for East Milton Square cannot ignore this market reality while it continues to struggle with its competing desires, some development goals to meet, and keeping the area as it does now. And it talks about stepping back buildings and 5-story buildings. And then it shows prototypes of buildings. And what does it show on this property? A 5-story building projected by this commission. So, it seems to me that if that's the way of the future, and we're going to be held to criticism here for not reviewing the applicant's application on the merits, but by usurping the decision-making process by trying to prove we're a planning board, and we're not a planning board, and that's one of the problems we have. We're a quasi-judicial body. So sure, if we think the health or safety is enough to reduce the mass of the building, then I guess where's our evidence of it, other than trying to make it up because we don't like the size of the building. And that's a concern that I have when you walk away from your own expert's testimony because you don't like it, and you start to superimpose your own views, whether the building is too dense, knowing we all would like to see a less dense building. And we have an applicant saying, if I go below 92 units, this is an unfeasible project, but who won't prove that to us? I think we're on very tenuous grounds in writing a decision, and I think HAC is going to just say, welcome back, Milton. This is what goes on all the time. Jeffrey, what do you have to say? Oh, Judy, do you want to say something?
Just a little thing. I think the perspective of the peer review consultants was not that everything they had said was addressed, but that the remaining outstanding issues were ones that could be addressed through conditions of approval.
Okay.
So that that in fact is why some of the conditions are in here, just to be fair to everybody.
Okay, I don't disagree with that, but I think the conditions are talking about a building that has 92 units in it.
Well, I didn't put the number in because I wasn't sure what you wanted to do, but that, that's what the applicant's requesting.
Yes, yes.
Yes, I'm concerned about what you just said, John, as well. And the only thing I'll say is I don't think the peer reviewers are our experts. They're our peer reviewers.
Well, I think that's true. They're the town's experts, I guess.
Yeah. And I agree with what Nick said about each and every piece of testimony is important, regardless of where it comes from, whether it comes from our peer reviewers or from Mr. Galvin or from the neighbors themselves. But what I heard is an overwhelming concern about density in the square that exists today and that will be worse tomorrow and probably worse the next day. And I think the town has a significant issue to deal with or without this building. I think the master plan is a truth that we need to address, and you can't wish it away. I guess my thinking on this application was that we needed to do the best we can based on the evidence and listening to all of the testimony, with the overwhelming weight of the testimony being around how to live and coexist in a congested area. That leads me to say I think we need to focus on the traffic and parking by things like controlling the jumping of the curb on Franklin, for example, making certain that the delivery area works, the courtyard that trucks can get in, like we talked about, and limiting as much as we possibly can the use of the available parking by the residents through the discussion we had about the MBTA and an incentive program. I'm particularly concerned about guest parking, because my thinking on the guest parking is that that's the most susceptible to being to losing parking to the residents who have available parking on the surface of the street, because that's the day parking. And the owners will, because of the restriction on overnight parking, I think that's a little bit of a less concern. So that's one bucket of concerns. And I think there's a big construction issue here, given we heard a lot about that from Sean Reardon. So I think, for example, we need a detailed construction management plan, and I think that needs to be approved by the building inspector. I also would go further than this. I haven't studied the draft closely, but I'd go further than the draft goes in limiting parking. This is going to be one of those sites where the construction workers are going to take the sites at 5 a.m. and the square is going to be blocked up all day long. We need a comprehensive construction parking plan that doesn't use neighborhood streets to park. And I would, that's nothing, there's nothing new to that. We have that at Brush Hill Road already. I'm sorry, not Brush Hill Road, Blue Hill Avenue. Parking is, in that case, is permitted on site, but nowhere else. And we had conversations with the developer about busing people in. I think that's probably appropriate here. And then I think it needs to be a conversation about mitigation efforts on the displacement of the surface parking. I understand the issues surrounding the developer's obligation, but I still think there's a local concern about the viability and the vitality of East Milton Square. So I know that Judy addressed it in the draft, and I appreciate that, but I think we could do some more around that. So those are my immediate thoughts on 3 buckets of area issues that I think could address the issues that were most prevalent in my mind to the hearing, while also being consistent with the kinds of testimony we got from both the peer reviewers and the neighbors.
Yeah, well, I agree with that, Jeffrey. I don't see any difficulty, but what I think we're doing if we follow that suggestion, we're doing just what Tim said, essentially. Be dealing with specific issues regarding the project. I suppose attaching those as conditions in some way if they're not already attached. The conditions here are extensive already. Maybe sharpening those up a little bit. And then passing it along to Hack to.
I'm not giving anything to Hack. We're going to issue a comprehensive permit. We're going to let the recipient decide whether or not they like it or not, and
Well, they're both going to appeal. They're both going to appeal, and that's their prerogative.
Yeah.
But where does it get us? I guess from my perspective here, it gets. How do you address Nick's concerns? I think
best you can. He's a good friend and a neighbor.
Okay.
I think some of what Jeffrey is talking about addresses my concerns. I don't know. I maybe I'm giving more weight to what than I should to what I heard, with one exception, universally from everyone who lives in that neighborhood. The one exception is somebody who lives in my neighborhood, as I recall, that was in favor of it. And I just want to do the best job that we possibly can on this project, given the evidence. As I'm sure the developer does, the applicant doesn't, is in their own way. I don't know where I'm going with it, except anything we can think of, any condition that we can put on there that will help mitigate the effect of this building to that neighborhood, I think we should strongly consider.
Agree with that, 100%.
Well, no, I don't think anybody disagrees with that. But maybe I'm jumping ahead of the process, because from my perspective, we can do that, but and pass it along, and we've done our job, and but it's not going to it's not going to change the project with any degree of significance. It's just writing a fancy decision that nobody's going to pay much attention to, in my view.
Except that Jeff is on the right track in that you do what you can to mitigate impact. So, anything that you might suggest around, strengthening the conditions around, access to the site, or the parking, or the, MBTA pass, or any of those things that might effectively reduce parking demand in the project, and therefore reduce parking impact on the neighborhood. Those are valid things that certainly, given the abundance of what's in the record about concerns about parking, and traffic in that area, those are well within your rights. Now, whether the applicant will like them, who knows? But
well, we don't care what the applicant likes or doesn't like. I guess the issue is, other than doing a list of 8 or 10 issues that should be explored in further detail, we're not technicians, we're not planners, we're not engineers. And so we'll write a bunch of lawyers talk, attach it to the decision, and punt it to Hack. And maybe that's what should be done. Maybe that's what the process calls for. But I don't think in the long run it's helpful, and I don't know that anybody at the Housing Appeals Committee is going to pay any attention to what 3 lawyers think about parking in the area or whatever. So I think it's putting, I won't say it. I was going to say lipstick on a pig, but I don't think that. It's doing window dressing on a project that will have no ultimate effect on what gets built or what gets decided.
So the only thing I'm going to say,
I'll go in that direction. That's fine with me.
I'm just going to push back a little bit, because the board has issued comprehensive permits for 2 projects so far, and in neither case did the applicant appeal to the Housing Appeals Committee. So I just think we need to bear in mind that your track record is not that everything ends up with the HAC.
No, but it ends up in the Superior Court or in the land
I
court.
understand, but when the applicant hasn't gone to the HAC, that is very much advantageous to the town.
Well, it may be from a political standpoint because of their particular persuasion and ideology and all of that. But
Well, no, it's the point that the law is clearly on the side of the production of affordable housing. And the courts are generally reluctant to disturb an approval of a comprehensive permit unless there's some overwhelming reason to do so. I mean, the law is very clear. The intent is to get affordable housing built. And that's why the scales always tip to the balance of regional need until you hit that 10%.
Yep.
I mean, people get frustrated with the HAC, and God knows I do too, but they're living with the same law. The direction of the law is that the regional need outweighs local concerns until you get to 10%, unless there is some overwhelming public health or safety reason or issue that no amount of mitigation can fix.
right. So if we write a decision, we spend the next 5 hours doing conditions and fancying up the language and all of that. And we enter a decision allowing the project, but with these additional conditions and the ones that you've put here. Then is it the prerogative of the applicant whether to appeal to HAC
Yes,
or to the Superior Court?
the applicant will go to the HAC.
Well, I know they will for political reasons, but
Well,
are they
But no,
required
that's
to
not
do that?
true. Not every project goes to the HAC. I think we need to be careful here.
That's what I'm asking you. Why would the applicant here not go to the HAC?
Because they think they can implement your decision. They think they can live with it. Just as 582 Blue Hill Ave decided they could live with the decision, or the Ice House said they can live with the decision. And this applicant may decide to live with the decision that the board, if the board approves the project, and they have any prayer at all of living with the conditions that you impose, they would probably prefer to do that than to spend a couple of years at the HAC.
Yep.
So I don't think it's valid to just assume that things end up at the HAC.
Okay, you're probably very right there. But isn't it reasonably probable that if we write extensive additional conditions or spruce up or beef up the conditions, and the applicant wants to live with that, don't you think that the neighborhood association will file an appeal?
They might. They might.
Every decision, every 40B project we've had here, with the exception of the Ice House, has gone to litigation or
I
appeal
understand
in somehow. And the Ice House was an exceptional circumstance where you had a developer who was very cooperative, and but I'm not sure that's a proper example. So I guess the point is it's going to end up in litigation. So somewhere, who knows where. And so I have no problem going forward and doing a checklist of fancy conditions and then approve the application and wish everyone well. And that wellness is probably 5 years of litigation somewhere.
I guess my view on that is, I think it's important to be mindful of the rights of the parties, but I don't think that should drive our decision making. I agree with Nick.
I agree. I'm talking reality. I'm not,
I know you are.
It's not going to affect our decision.
Yeah, and the best thing to do is
what you're saying then is that on the issue of density of the project, which I thought was one of the biggest issues here, that's for somebody else to decide.
No, I don't think we have evidence to do anything other than mitigate the impacts of that density. In other words, there aren't specific things that anyone has recommended that we could rely on, which we could rely, short of redesigning the project. I think the closest we came to that was the step back on Franklin Street, which was at one point suggested and then ultimately disregarded by Mr. Bomer, upon whom we relied a lot for the look and the feel of the building and for the massing. And that, I mean, I guess my view of the hearing is once you get to that point, then it starts to become a conversation about engineering. And we talked a lot about stormwater and offsite infrastructure impacts and traffic and parking.
Well, let me ask you this. Do you think, Jeffrey, that that the issues which you've outlined in a very general sense, not holding you to the particular items that you mentioned, do you think that they have not been addressed by the peer reviewers, or they've not been addressed in the draft decision we have in front of us?
Yeah, I think both are true.
Okay.
I don't think they've been addressed by anybody at this point. I think there's evidence in the record to address each of the issues that I raised. And I think that it's not that much work to work with the draft, which I agree with you, John. I think it's really terrific and super helpful to spruce those up, to be consistent with, something. I mean, I think we work with so I like to use the phrase, let's say, sense of the room, right? So you get a sense of the room. And I don't think it's that difficult. I don't know that we could do it right now because, we got it a couple of days ago. I know people have read it, but, I could see where the next draft could be sharpened up. And I'm sure that that's exactly what Judy's expecting. Yeah. And some of what she's put out there is, hey, what do you think? You're the board, so that's all fair game, but like I really want to incent these owners to not have cars, because I feel like if we can't do it here, we're not going to do it anywhere. So we need to do better. We need to work harder at that issue. And I think that goes to one of the, if not the central issue that we heard from, as Nick said, very nearly everybody. And that's super important.
Nick, you want to be heard?
I don't think I have. I mean, I like the direction Jeffrey is heading. I guess I just keep coming back to the weight of the fact that the evidence of the neighborhood is evidence that we're entitled to take into account.
Yes, it
even
is.
Even if it disputes or goes farther than our peer reviewers have gone. I think we're entitled to take that into account when setting conditions and making our assessment of the project.
I agree with that. I don't disagree with you.
So
what I disagree with is I think that you're not giving appropriate weight to what the experts on both sides here dealing with all of these issues have said. It's fine. The neighbors can object for a wide variety of reasons, but if they start objecting to what is tantamount to engineering theory and whether the water retention system is going to work or not work or that type of thing, I'm not sure how much weight that type of evidence should affect our decision, as opposed to what evidence we have from the experts in those particular disciplines. So, but I hear you.
My concerns are not so much with the stormwater effect of this. I understand that the comments made by Mr. Reardon, I take him at his word when that we can design, that system's been designed and can, with appropriate conditions, will be satisfactory. I'm less concerned with that. Just more concerned with how people are going to be able to live with this development, including the people who live in the development. Let's not forget they're also East Milton residents and will have to deal with the effect of their building along with everyone else. I don't know. I'm just
Nick. How about this?
Yeah.
If you look at what I'll call Judy's vision for the town of Milton, with her other.
Mine.
Well, no, I appreciate that, John. You read that. That was very informative.
How are people going to deal with 4
Yeah.
buildings or 5 buildings?
5 buildings like this, your point is very well taken. You know,
And if the zoning is changed, they may not even be 40B buildings.
yeah, this is true.
And what amazes me a little bit, but I don't do urban planning, is that the review or the study, I think is sometime in the middle of 2021. I'm not a zoning expert, but I haven't seen any proposals or definitive suggestions how to change the zoning in East Milton Square to comply with the needs of that particular proposal. Now, maybe that'll happen in 5 years from now or 10 years from now, but in between then, those 4 buildings that are going to get built down there are going to be 40B buildings.
I think that the Master Plan Implementation Committee is looking at moving forward with that, John, just so you know.
Yeah, and do you have any idea how long that'll take, Judy?
No, I don't. I know that there's an interest on that committee, and Tim can probably speak to that more than I can, but I think to try to move forward with some zoning implementation of that plan.
I think that'd be helpful to hear because I think that's super important here. And I think that the plan that the town published in 2021 is also important, especially to external parties who are looking at this hearing. So I'd like to hear from Tim about the plans because I agree with John. If the zoning gets changed, it's going to create a completely different dynamic here. And what's the likelihood that that happens?
So
how can we base a decision on this? What's the speculative?
No. I'm not saying we should, John, but I think it would help to have an idea of where this is going, you know?
Okay, yeah, okay, that's fine. Tim, are you able to weigh in on that, or is it?
Yeah, and what I can say is that starting back in 2018, 2019, there's been a desire, and it's actually been sort of instigated by this project and its predecessor project that was spearheaded by the Falcone companies to kind of look at East Milton and kind of come up with a development vision, for the neighborhood. And so that, we invited the Urban Land Institute to come in and do a technical assistance panel that, led to work that Judy's company did with a group of East Milton stakeholders, residents, business owners, civic leaders to try to come up with a development vision. And that's led to, the typical planning process is then, you look at how do we actually implement this vision via land use regulation. And so the planning board has actually expressed an interest in, dedicating, a significant portion of its next fiscal year budget into, planning in East Milton and potentially coming up with a new zoning regime that will, obviously that's as far as it goes without actually, talking to people, doing the analysis, really kind of looking into and digging down into the feasibility of certain building types and certain land uses. So, what we've got now is, a stated intent by the planning board to, to consider zoning in this neighborhood. What that actually comes out to, if it's, more similar to this project or more similar to, some shorter and less dense projects is really going to depend on, a strong community outreach effort and a significant amount of analysis on kind of what that language looks like. But, so it's not there's no definitive answer here, except that, the activities of the planning board are pointing in the direction of, a consideration of new zoning in the neighborhood.
Is that helpful, Jeffrey?
Yeah.
Good.
Thank you.
Okay, so what do you suggest? At least I infer from what you said that you think that the board needs more time to review the draft decision and its conditions, and to see which, if any, of the conditions need further review and further definition and further elements to be included. And if you do, I think you said we weren't prepared to discuss that tonight.
Well, we
So-
could, but I don't, I mean, I'm not, you know, I don't want to overstate something that I don't completely understand because I haven't studied the decision. That's all, you know, I mean, I talk broadly, but I think some of the details are really just going to need to be thought through and reduced to writing. At least that's what we did on Brush Hill Road. I mean,
Blue Hill Avenue.
40Bs on Blue Hill Avenue. And then Judy consolidated that into one. And then we
Okay.
finalized that, you know, from there. I don't know.
No, I don't disagree with you.
Okay.
The question is, what do we do? Do we adjourn this meeting and agree to circulate some type of a memo or via emails as to the issues that we think should be expanded on in terms of conditions?
You probably want to run them through me so that you don't have an open meeting law problem.
Okay,
But I mean, Jeff, we did go through the 582 decision, went through a couple of rounds of edits just because the board, all I can do is try to just get the structure going and, connect in what I can of the evidence, but the board always makes it much, much better. I mean, this discussion tonight has been helpful to me too. So I think if you guys want to have at it with the draft, route it back to me individually, and then I can do a consolidated version.
Mhm.
And if there's a conflict between something that two of you or three of you say, I can footnote it and say, you need to resolve this, guys. But if there's no conflict, I can just, integrate it into the decision, highlighted or, red line or something to show you what's changed. And then you can discuss that. And so you've got a revised version now that maybe has some consensus in it.
Yeah, I don't foresee any substantial conflict. I think we're all going to be in basic agreement as to if you need more definition in terms of the conditions. I'm not sure we're going to have any disagreements about that.
Yeah, I have one.
I don't think so.
I'm sorry, Nick.
No, I agree with what John was saying. I don't think we'll be in any substantial disagreement.
I think the waivers need some work. The waivers came out way too general for my taste.
Oh, yeah.
You know? Judy noted in the introduction, which I think now has become town boilerplate, that we're only waiving what we're waiving. And we need to be much more purposeful about that. So, I should have added that to my other list of concerns, but that the waivers are going to need some more detailed attention.
Okay, so
And that can be done.
is the suggestion that we adjourn this meeting, review the draft decision, and make comments on it directly to Judy, and then, if need be, at our next hearing, discuss those issues.
Yeah, I would recommend maybe that Judy, deputize Judy as the keeper of the record, and maybe Judy could assist us in identifying, well, maybe you'll be able to turn a draft that will identify the issues, because from my perspective, the next meeting, it's going to more resemble a page turn, or at least a page turn on the major issues. There are going to be a handful of issues, 20 issues, maybe, I don't know, 10, that you're going to want to talk through and say, okay, this is what I was really wanted to see, or, we may have some conflicting comments. I don't know, Judy's been through this already, so she knows.
How much time do you folks think you need to kind of take that draft and mark it up?
Well, this is all about the weekend, so It's gonna be done by Sunday night, right? So, from my perspective. So I'll get it to you Sunday night, Judy.
Okay.
I don't want to speak for Nick. He's got bicycling day.
It's taxes and hiking this weekend. I'll find a way. I don't want to be outdone by Mr. Mullen.
John, what works for you?
Well, Sunday may be a little close, but certainly maybe Monday, sometime before the close of business on Monday, that'd be good for me. But I do have to tell you, as of Wednesday, I'm gone. And
For how long?
I will be gone till the 2nd.
What's our
Tuesday.
40-day deadline? I know you were tracking it, John. I don't have it in front of me.
I have April 11th or the 12th.
Where you going, John?
Oh,
Where you going? South Boston?
no, they're throwing me out of South Boston, Jeffrey. I'm persona non grata there anymore. I'm going to Asheville, North Carolina.
Ooh,
Back to college?
No, I didn't go to University of North Carolina. I'm going there for a joyous family wedding.
Great.
But I'll be back on the 2nd. I'll be back Monday the 1st, but available the 2nd. So,
so John, can you get me a markup before you go?
yes,
Okay.
I'll have it for you by the 21st, by Monday the 21st at the close of business.
Today's the 24th.
I'm sorry, what am I? I'm looking at April. Hold it. The 28th. Close of business Monday the 28th.
Okay. So, I mean, even though you're gone, I mean, I certainly can work on that draft for a couple of days and just send it back to you guys. And so when do you want to meet again? I think that's the important thing is when do we need to plug in another meeting here?
So did we want to meet next week or can we not do that?
I just, for me, it's a question of turning it around, Crystal.
Yeah.
It's just getting the decision redrafted so they can
Right.
have it to review.
Okay.
I mean, it's probably a blessing that if we don't meet next week, only because every night is booked. It's just a mess.
Yeah.
Oh my God, it's just a mess. Next week is so bad.
There has been a lot and
Yeah.
there's quite a few meetings next week as well already. So
How about the 5th, Tuesday the 5th?
I can make that work. I don't have, well, yes, I can make it work. There's a possibility I may have to be at an Andover town meeting that night, but I don't think so.
does 7 o'clock still work for everybody? Is that the time? I mean, do you usually meet any earlier or is it always 7?
I wish they met earlier.
Okay.
Well, I think earlier is an imposition on Jeffrey. I think
I know.
we've run around the track a few times on that. So
Okay. I wasn't sure. So Tuesday, April 5th at 7 o'clock.
it's fine with me. How about you, Jeff? Not that too late for you? Would you rather have it earlier? No. Nick, how about you?
Oh, that's fine.
Okay.
Crystal, can you send an invite? Would you mind?
Yeah, please do.
Yeah.
Sure.
That would be a big help.
Okay. No problem.
Nick, that's what happened on Randolph Ave, Nick. I just didn't have that on my calendar.
I happened to me. I didn't have it. I know we probably
Oh.
talked about it, but I booted it as well.
Yeah.
It's just too bad because I want to see it.
We'll go over there together. I'm gonna take him up. I want to drive up that driveway.
I'll do it.
We'll go together. Take my truck.
I want to make some left turns.
So you're content, Judy, with the 5th? We don't want to put undue
Yes,
pressure.
sir. It's fine. I don't think I'm going to have an Andover town meeting that night. I think we'll be fine.
Okay, is there anything else to discuss?
I don't think so.
I'll just throw one issue out on the table, and that is the issue of corporate identity here.
Oh,
Mr. Galvin has raised the issue of whether Adams, well, let me get the exact name of the entity.
the LLC, Adams Court LLC.
Yeah, whether that exists or not, and whether that's of significance in the case.
Well, that is the name of the applicant entity, so I don't know how you can grant the permit to anybody else, but that is the name under which they applied for the permit.
Right.
I
Right.
would agree with that.
I disagree with that, but I understand what you're saying. What they did here, and maybe we should discuss it now, is Joseph J. Corcoran Company LLC is the controlling member of the applicants. And they were going to form an entity by the name of, I think it's Adams Court LLC.
LLC, right.
And I'm not sure that entity has legal existence.
I don't know how we would have any evidence now in the record that we could use to address that.
That may be, and I don't know how the process can be letters to the state agency, submission of materials to the state, decision making by one of the state agencies. You'd know the exact name, Judy, as to what were the relevant issues and all of that. If the applicant doesn't exist, but I honestly don't think the applicant does exist.
I don't know.
Well, we can verify whether it exists or not easy enough.
Yeah.
I have.
Oh, you have?
I have. I don't think the Secretary of State's office has the applicant as an existing.
But what do you do with that now that the hearing is closed?
Well, I don't know. It wasn't raised by anybody at the hearing. It wasn't raised before any state agency. It was
Right.
And it was been a non-issue until Bob Galvin put that in his request for findings.
I wouldn't begin to know how to address that at this point. It's the name of the applicant entity on your application.
Well, the interesting thing is that the state agency, I don't think I have all the paperwork here. They were sending the definitive information regarding the project and what it should consider and all of that to the Joseph J. Corcoran Company, the controlling member, and not to Adams Court, which I think was just a shell corporation to take.
Adams Court LLC will be the limited dividend organization.
Yeah, and so I think because of COVID and delay in the project and all of that, I don't think Adams Court LLC was actually recorded with the Secretary of State's office.
I don't know.
I don't either. I just wanted to raise that because that may be an important issue or may not be an important issue if everyone was dealing with the Joseph J. Corcoran Company as the controlling member of the applicant, and because of COVID concerns or otherwise, delays in the application, somebody does not record or register, I guess is a better word, the applicant with the Secretary of State's office, and everyone's proceeding on the basis that we're really dealing with the Joseph J. Corcoran Company, LLC. I mean, I suppose that's, from my viewpoint, that's probably the real applicant or the real party in interest. Maybe not the real applicant, but the real party in interest here.
So the project eligibility letter from Mass Housing for the ice house was addressed to Charles Bosworth. I'm telling you that the LLC entity is the limited dividend organization.
Yep.
So what the applicant agrees to do is either have or will form a limited dividend organization, consistent with the requirements of the subsidy program.
Okay, well,
That's the entity that holds the permit.
is the Joseph J. Corcoran Company LLC a limited dividend corporation?
No, Adams Court LLC will be,
Okay,
I believe. I mean, we're probably talking about stuff that is not in the record, but that is my understanding, that they would be the limited dividend organization.
what do we do if they don't exist?
Well, if they don't exist, they can't use the permit. It's a useless permit.
If they don't exist, how can we grant the permit to a non-existent entity?
I cannot answer these questions.
I mean, this is metaphysics, but I
understand, but I
if they
cannot
don't
answer.
exist, there's no plaintiff or applicant. I mean, right?
I think you're going to find that the LLC in the case of the Ice House also, quote, technically did not exist at that point.
Interesting.
No, the suggestion is that that's a nominal plaintiff, but if as and when the approvals are granted by the state and by the Board of Appeals, the entity will be formally incorporated. I just don't know what the practice is in.
I don't think it's at all uncommon.
Yeah, okay. I guess it doesn't surprise me, but I would think for $500, I'd like to have that issue go away or not exist. But it may be that's the usual course of doing these things.
I don't know.
The limited dividend organization, if that's what you called it, Judy, it has really no significance until it receives a special permit or something is granted.
That entity, the limited dividend entity, whatever it's going to be called,
yep,
has to exist in order to go forward with the subsidizing agency.
Okay. So is it your experience that if we grant a permit here, that it would be granted in the name of Adams Court, whatever it is, and it would be the burden then of the applicant to record itself and to come into legal existence?
Yep.
Okay.
I mean, the applicant's own attorney drafted a permit in that name. So that's what you have in the record.
Okay, I mean, it just seemed to me to be a little informal, but on the other hand, if that's the way that I won't say the industry, but the way these things are processed, I guess that's the way it is. It's an unusual way, considering the time, money, and expense that everyone has gone to here.
I can't comment. I just don't know.
Well, okay, I just thought I'd mention that issue.
It's not the first time I've heard this. I guess I'll just leave it at that. But over my head to address this matter, I'm simply pointing out that the applicant's own attorney drafted a permit in that name.
Yeah, is it common from your perspective, Judy, that these applicants that receive these special permits, they're essentially shell corporations and not corporations with significant assets. And once they get their permit, everything is funded and goes forward.
I'm not competent to answer that question.
Okay. I mean, I've heard of that in development.
I think it probably is, but I'm not an attorney and I am not competent to answer that question. And you're asking me something that's beyond the record that I can treat as my little box of what I can help you with.
Okay. Jeff, do you have any comments?
I don't know anything about this. I'm sorry.
Okay.
I think this is a solvable problem, but I just don't have enough knowledge.
All right. Well, that can be on our checklist, I guess, as we
I think that's right.
go along. So, anything else anyone wants to discuss? Crystal, are you all set?
Yes, I'm all set.
Okay, so we're going over to April 5 at 7 p.m. to further discuss the meeting, and the suggestion is that well before then, and hopefully sometime Sunday or Monday, comments on the draft will be sent directly to Judy Barrett.
Much appreciated, guys.
Everyone agreed?
Yep. Thank you, Judy.
Thank you.
Thanks a lot.
Okay.
All right.
Well, thanks a lot, then. We're adjourned to the 5th at 7 o'clock. Thanks,
Great.
everyone.
Thank you.
Be well.
Bye-bye.